All right. Hey, guys. Welcome back to the Carl Jackson Show. Again, your daily dose of objective truth in a world of confusion and lies. The Trump administration had some victories with the Supreme Court both yesterday and today. And so I want to talk about those victories with my guest. He's on frequently with us. Brilliant mind, legal mind, and that is Zach Smith, attorney Zach Smith, constitutional attorney of the Heritage Foundation. Zach, thank you so much for joining us again today.
Of course. Thanks for having me on the show, Carl.
Okay, so Zach, let's do this. Let's start with this case that was resolved today, April 8th. This is Tuesday, April 8th. Let's talk about this. The Supreme Court halts this order to rehire federal workers that were removed by the Trump administration. And I think these are some huge victories coming down, not just for Trump, but for the American people, albeit we'll get to the next case. And even this case, frankly, what I'd love to know from you is just how deep is this victory? Are there some things that we need to be concerned about, even with some of these decisions or a couple of these decisions? So today we got the Supreme Court that blocked the federal judge's order requiring Trump to rehire thousands. That was absolutely insane to me. Thousands of fired federal employees. I don't know how, again, a federal district judge believes that they have that authority. And this was U.S. District Judge William Alsup, I guess, in San Francisco.
Yeah, look, Carl, there's no doubt this case and the other case we'll talk about involving the Trinidad and Aragua gang members are both wins for the Trump administration. And what the Supreme Court said in both of these cases certainly vindicate the legal positions that Donald Trump has been taking in court so far. But while these are very important wins, this is only the beginning of the battle because the Supreme Court essentially resolved both of these emergency motions on procedural grounds for now. And so the underlying litigation on the merits can continue in both this case involving federal workers. It will continue in the Trinidad and Aragua case. And so the merits determination still has to proceed forward. But in this case in particular, involving the federal workers out of San Francisco, essentially what the Supreme Court justices said in a 7-2 decision is that the groups that were challenging this dismissal of these workers essentially didn't have what's known as standing. They didn't have the legal ability. They themselves didn't show sufficient injury to be able to bring these challenges. So there are other claims that could still percolate their way through the federal court systems, but at least for now, these specific groups in these specific challenges cannot proceed forward.
Okay, so we're not totally out of the woods yet. In other words, again, this is an emergency motion, which SCOTUS granted, and this is a win, but this isn't necessarily the win that we want ultimately that would restore this power to the executive branch. Am I going too far with that?
No, that's exactly right, Carl. And look, fundamentally, if we get down to brass tacks, what is this case about? It's about who controls the executive branch of the federal government. Is it the president, which Article 2 gives the president and the president alone the authority to exercise the executive power of the United States? Or does Congress have the ability to take away some of that executive power? Do courts have the ability to take away some of that executive power? And I think the answer to those questions is clearly no. And unfortunately, what has happened really over the last half century or more is that Congress, the courts, others have tried to impinge on a president's Article 2 executive powers. And what you see is Donald Trump and his administration now taking very reasonable steps to reassert some of that authority. I mean, think about it, Carl. What could be more core to the interest of the executive branch of government than deciding who should staff the executive branch of government? And unfortunately, I think we all know from Donald Trump's first administration that the majority of career bureaucrats do not like Donald Trump. They do not like the policies his administration is enacting. And unfortunately, too often, the career civil servants who are supposed to be helping to execute the administration's policies were in fact working against it and working to stop those policies from being implemented however they could.
I'm speaking to constitutional attorney Zach Smith of the Heritage Foundation. You can find him on X at TZ Smith. That is at TZ Smith. Zach, let me ask you, why do you think these judges, is there any indication that these judges in their minds were were being fair, or do you think this is just? I mean, I believe that it's just judge fair, so to speak. But is there was there any legitimacy, in your opinion, to any of these orders from these judges trying to stop President Trump from doing what I believe are his authority to be able to fire executive employees?
Well, there are a couple of points I think that are worth making here, Carl. During the Biden administration, we heard a lot of folks on the left decrying so-called judge shopping. They
Yeah,
claimed that conservative groups, conservative plaintiffs were going out trying to find favorable judges in favorable jurisdictions, and were trying to get their cases in front of those judges. Now, those accusations were made very vocally, in very personal manner against some of these judges, to the extent that some of the conservative, supposedly conservative judges that were targeted had to have 24-hour security provided by the Marshal Service, often at great personal expense. And yet today, we know for a fact that many of the challenges being brought against Donald Trump's executive actions, the left for a fact is engaging in the type of judge shopping that they previously decried. I mean, look at where these challenges have been brought, Carl. They've been brought in Washington, D.C., they've been brought in Massachusetts, they've been brought in the state of Washington and federal district court there. And then, of course, this case out of California. And so there's no doubt that these left-leaning liberal plaintiffs are trying to find liberal judges wherever they can to enter these temporary restraining orders. Now, that's the other half of what's happening here. Oftentimes, these judges themselves are trying to game the system in a very problematic way. And this is fairly technical, it gets into the weeds, but these judges are issuing what is known as temporary restraining orders, TROs. These are quick
right.
orders that can be issued ex parte in some circumstances, meaning both sides don't get a chance to present their cases. And essentially, they're designed to, in an emergency situation, freeze the status quo. But the reason these judges want to style their orders as TROs, temporary restraining orders, is because TROs are not typically immediately appealable. Typically,
Really?
the judge will retain the case at the federal district court for several weeks until he or she enters what's known as a preliminary injunction. And once that preliminary injunction is entered, then at that case,
Wow.
it can ordinarily be appealed. Now, the thing about it is, Carl, in many of these cases, these judges and the parties know that if the administration complies with the TRO, that getting effective relief down the road if an appellate court overturns the order really isn't possible. Think about the case where billions of dollars were going out the door. The judge in that case essentially issued a TRO ordering the Trump administration to go ahead and disperse the money. Now, I don't know about you, Carl, but I suspect once the money goes out the door, good luck getting it back in the door again,
Exactly.
particularly when a lot of this money was going overseas to foreign governments or to fund different foreign aid efforts. And so I think that's what many people are so troubled by, is the fact that these judges appear to themselves be taking not only a very expansive view of their own powers, but potentially enacting their orders or styling their orders in such a way so as to try to deprive the Trump administration of being able to immediately peel them up to the federal appellate courts and ultimately up to the U.S. Supreme Court.
Okay, so we have just over 2 minutes left in this blog, Zach, and we're talking about I'm speaking to Zach Smith of the Heritage Foundation, constitutional attorney. The Supreme Court has halted in order to rehire federal workers, and then we'll move on to Judge Boasberg in the next block here. But let me circle back and ask you something. The majority of the justices, and you made mention of this, but this is just crazy to me. So the majority of the justices said the 9 nonprofit organizations that obtained the injunction lacked standing to sue. And I'm like, duh. And then I got to be honest with you. I'm like, oh, I didn't realize there were NGOs that were suing the Trump administration to get these federal workers hired back. I'm like, I don't even know how that works.
Yeah, I mean, look, I don't think it will come as a surprise, Carl. There are NGOs bringing suits. Federal labor unions are often bringing lawsuits as well. And so a lot of people are trying to impinge on the president's ability to hire and fire whom he pleases to help execute his policy. So we still have a long way to go on this issue. Even though the justices lifted this federal judge's order, there's still currently in place a different order issued by a different federal judge in Maryland that still purports to require the president to rehire probationary employees that he terminated in about 20 different federal agencies. And so again, this just really highlights the problem, Carl, that with over 600 federal district court judges around the country today, any one of whom could purport to issue a nationwide injunction that would prohibit the administration from taking certain actions anywhere at any time against anyone. This is a very real problem, and we can talk about it, but that's part of the reason why you're seeing Chuck Grassley, Mike Lee, other members of Congress starting to put forward legislation to try to rein in the power that these federal district court judges are currently trying to exercise.
Yeah, I'm so glad, and it is it is about time. I think this has just gotten way too out of hand, and the fact that the especially with these TROs, the information temporary restraining orders that you mentioned, how these things could take a long time to appeal. I'm like, okay, these guys are just buying time, hoping to get to their guy when he gets in. Anyway, we have to take a quick break. You're listening to the Carl Jackson Show. More with constitutional attorney Zach Smith on the other side. Hey, Carl Jackson here from My Pillow. My Pillow is excited to announce that they are extending the mega sale on overstock clearance and brand new products. This is your chance to grab incredible deals on some of My Pillow's most popular and newly released items. For example, you can save $40 on the new spring My Pillow bed sheets available in any size or color. Also, these luxurious sheets are designed for maximum comfort and breathability, perfect for a great night's sleep. Looking for a meaningful gift? You can save 30% on the brand new My Crosses, inspired by the one that Mike Lindell has worn every day for over 20 years. These beautifully crafted crosses come in both men's and women's designs and are proudly made in the US of A. Get the 6-piece bath or kitchen towel sets for just $39.98. Initial quantities are extremely limited, so don't wait, por favor. And don't forget, the best-selling standard My Pillow is now just $17.98. Man, that is insane. Plus, orders over $75 ship free. So go to mypillow.com. Use the promo code Carl. That is CARL, or call 800-858-0263. 800-858-0263. All right, I'm back with my guest, Zach Smith. He's a constitutional attorney at the Heritage Foundation. You can read his work at the Daily Signal, heritage.org. Find him online at TZ Smith. And we're talking about the Trump got some Supreme Court. Frankly, I think America got some wins in the Supreme Court last night or yesterday and today, albeit emergency motions. I think this is good. Zach, I want to get to this case with a Judge Boasberg. I believe that's how you pronounce his name.
Mm-hmm.
I'm not trying to. Okay, so good. I want to get to him momentarily here, but I mean, what is this? If you were to take I don't know, just if you were to take, what am I trying to say here? Just looking into the future, do you think this is a major blow to, I believe, the left that tries to use judge fair? And I'm not saying Republicans haven't done some elements of judge shopping. I know that they have. But in general, it does seem like the left tries to use, whether it's lawfare, whether it's judge fair, people that they know, just like you mentioned earlier, they'll go to these blue districts or whatever. They'll get these left-wing judges, in my opinion, to try to go their way. Do you think this is going to put I don't know. Basically, do you think this is going to hinder the left from doing some judge shopping in the future? These decisions that have come down.
Well, I think it certainly sends a shot across the bow, Carl, in terms of that it looks like, initially the Supreme Court, the majority of justices were very hesitant to intervene and really step in and kind of rebuke these district court judges when they exercise this broad authority. And what you're seeing with these two cases in particular, I think a majority of justices on the court recognize just how broad, just how egregious some of the orders that these judges have entered truly are. And even though both of these cases, the one involving the employees, this case involving the Trinidad gang members, they're resolved on procedural grounds, but procedure matters, Carl. And again, I think, the Supreme Court stepping in, the majority of justices, I suspect they recognize that many of these federal district court judges are taking a very broad, a very aggressive view of their own power, and that is something that certainly cannot stand.
Okay, so this is interesting. So in the case that we spoke about earlier, where the Supreme Court halted the orders to rehire these federal workers, and this was U.S. District Judge William Alsup in San Francisco, who ordered the six agencies to reinstate 16,000 recently fired employees or laid off federal employees. Which again, I don't know how a judge believes he has the authority to hire or fire federal employees. That's just astounding to me. But I found something very interesting here too, Zach, and that is that you had seven Supreme Court justices that agreed that this was egregious or there was an overreach on this judge's part. Yet, when we get to Judge Boasberg, you had actually four dissenting, including Amy Coney Barrett. I've heard some argue that Amy Coney Barrett isn't a liberal, like I've accused her of being, but more so a judge of process. And so that's why she dissented in the other case. If you could give us a synopsis on that with Judge Boasberg.
Yeah, well, look, I think the process focus of Justice Barrett, that is a fair point to make. I've heard others make that as well. Obviously, she is a former civil procedure professor, and so process matters. And fundamentally, this case involving Judge Boasberg and the Trinidad Aragua gang members, it is a procedural case in the way it came up to the Supreme Court, and the way the Supreme Court ultimately resolved it does turn on seemingly mundane but very important procedural points. And so what the Supreme Court justices decided, a majority of the justices, as you mentioned, is a 5-4 decision. The five justices of the majority essentially said that the individuals challenging their removals under the Trump administration's executive order invoking the Alien Enemies Act is that they weren't challenging it through the proper mechanism or in the correct venue. Typically, in order for these type of removals to be challenged, the individuals challenging them have to file what's known as a habeas claim. This is a well-known legal procedure that's existed since the founding of our country. It's existed before the founding. It was known at common law, and it basically means to produce the body. You have to produce someone, and they get a chance to say why, in their view, they're being unlawfully detained. And under habeas procedure, the person bringing the habeas claim has to bring it where he or she is currently detained. And because many of these individuals who are subject to this removal order are currently being detained in Texas or in different judicial districts, they would have to bring those claims in those judicial districts rather than in the court where they brought them. And I think that's what Justice Brett Kavanaugh, he wrote separately to emphasize that point, that the court is not saying that these individuals do not have due process rights, that they're not going to be able to air their claims in some sort of judicial forum. It's simply about what is the proper procedure, what is the appropriate judicial forum for those petitioners to bring those claims.
Okay, so now that's a little disconcerting to me, and I'll tell you why, Zach. I'm concerned that what will happen is that, or if we're worried about, I guess that's habeas corpus, where you have to produce the body. Someone has to be in a courtroom. Is that right? Someone has to be represented. The person being charged, or I'm guessing I have that right. I don't know exactly how to explain it. But if that's the case, isn't it going to make it a lot more difficult, even though Trump has the authority to use the Alien Enemies Act to get alien criminal enemies out of the United States of America? I mean, it seems like a victory, but then I'm not so sure at the same time.
Well, I think it does vindicate, in some sense, what the Trump administration has been arguing. Because, look, I think the Trump administration itself recognized in this case, in their legal filings, that even those Trinidad Aragua gang members, and I think this speaks to how revered our legal system should be, Carl, even these gang members that have been declared to be a part of an international terrorist organization, even they are entitled to due process rights. They're entitled to notice of the charges against them and why they're being removed. And Donald Trump Trump's legal team said that in their legal briefs. But look, I think we're going to see future litigation about whether Donald Trump's invocation of the Alien Enemies Act, whether that's appropriate in this case. It's been rarely invoked throughout our nation's history. And again, this is an issue that sometimes divides legal commentators themselves. But look, fundamentally, this is a victory for the Trump administration now. Their legal position has been vindicated in court. And so for Sarah Harris, who was the acting Solicitor General when this case was being brought, and her legal team, I say kudos to them for a job well done.
Amen. All right. So due process in this instance does not necessarily mean that every one of these individuals are going to be ramped up into some long drawn out court battle within the United States. It could mean that maybe they're being served papers, they're being read, I guess, Miranda rights. If they're in the United States, they're being told what their charges are before a deportation.
That's right. They get some type of notice about why they're being removed. But look, Carl, fundamentally, this is about, and I think this is what Donald Trump's legal team said as well during the course of this case. Fundamentally, this comes down to who gets to decide sensitive national security decisions affecting the United States. Do we want the president of the United States, who's been duly elected, making these types of important, sensitive decisions, or do we want a random district court judge making these types of decisions? And I think it's clear the law and the American people want the president making these types of decisions.
Yeah, no, there's no doubt about it. In that sense, it is definitely a huge win. I was so relieved when I heard both of the results from these cases. But I hope this will deter judges in the future that want to be activist judges against this administration. Do you suspect that we'll see less judge fare going forward?
Hope springs eternal. I certainly think we should see fewer judges issuing these nationwide injunctions. I do think it's a good sign that you have Chuck Grassley, Senator Mike Lee, others on the Hill getting serious about putting in place codifying procedural protections to essentially make it much more difficult for judges to issue these nationwide injunctions. Look, these nationwide injunctions that we've been talking about, these have been unknown for most of our nation's history. These are really a development in the last 20 to 30 years or so, and the overwhelming majority, have been applied against Donald Trump and his administration. The framers of our Constitution would have been horrified by the types of nationwide injunctions we're currently seeing being issued by federal district court judges. And so I am hopeful that this will lead to larger conversations and potential codification of some reforms that would make it much more difficult for this type of lawfare, this type of judicial overreach to take place in the future.
Yeah, and I'm guessing that there are some criminal aliens that are in this country that are paying attention to this news, and they're getting maybe they're going to self-deport. One can only hope. Just real quick, we only got 20 seconds, probably too short to ask this question. But Kagan, she sided on one side and then with the other. What's your take on Kagan? She seems to be a liberal but reasonable.
Well, look, Justice Kagan, she is incredibly smart. She is certainly not an originalist or textualist, and often I disagree with her decisions. But I would say compared to some of the other liberal justices, Justice Sotomayor, Justice Jackson, certainly her opinions tend to be very thoughtful.
All right, we'll leave it there.
All right. Thanks for having me on, Carl. Great talking with you.